Happy Friday to everyone. Thank you so much for stopping by this morning. You saw the thumbnail, you saw the title, and you know what we're about to do. I want to first of all say thank you to every last one of you. As a member of the channel, you really have helped bolster this channel and support me in ways that you really, truly don't understand. So I want to say thank you. And I want to make sure I do more of these. So please hold me accountable now. Make sure, hey, Jason, here's some members only content that you could do. Or Jason, don't forget about us members, because I want to make sure that you all stay front and center, because you all really, really do mean a lot to this channel. All of you mean a lot. And I just want to say thank you to each and every one of you. Thank you so much. Now, today, I want to real quick make sure that you all can actually see me. It looks like everything is going in the right direction on the old YouTube. I want to make sure that's correct. And it looks like it is. So I'm going to take YouTube for its word and say that they did, in fact, make sure that this got out there to everybody and everybody knows that it's here. I think it is. Okay. It looks good. But let's just check real quick. Okay, I hear it. Sounds great. Okay, let's call it a game. Shout out to you, YouTube. Keep it up. Keep it up. All right. Thank y'all so much. Let's talk about this thing, because this is something I really, truly do not understand when it comes to law. A judge can do something that is completely and totally out of pocket. And it almost seems as if there's no way for them to ever say like, oh, wait, I made a mistake. Yeah, that was my bad. I shouldn't have done that. That was wrong. I take that back. Don't worry about it. That's on me. Something of that nature. It doesn't seem like there's anything like that in law. Or maybe it's just not practiced enough, because most of us have seen and were present for the infamous Brian Steele gets held in contempt and thrown in jail for 20 days debacle. And I'm pretty sure, if we could be honest, I'm pretty sure Judge Glenville realizes that he stepped in a big giant pile and it was really his fault. Whether he agreed that Brian Steele should know about the ex parte or not, the issue is that he was the linchpin, if you will, for those crazy event. Why can't Judge Glanville just say, you know what? Yeah, I kind of blew up and said I was gonna put you in contempt and had you arrested and had you take your tie off and all that kind of jazz like that. But you know what? After I thought about it, I was wrong. And why can't he just do that? And maybe he can, and maybe it's a fault of Glanville, or maybe the system doesn't allow. Once you go in one direction, you cannot turn around and go back and course correct. It just seems really problematic. And all of that opening is simply because y'all might have forgot about it. Maybe you didn't. I don't know. But Brian Steele still has to deal with that contempt charge from back in June. And so yesterday was this case is moved up to the Georgia Supreme Court. So this has gone pretty far, and it's pretty bad. So what I want to do is we're going to just go through this rather quickly. It's about 46 pages, give or take. There's some repetitive stuff in there, but I think it's definitely good stuff to go over. So let's just look at it. In that Supreme Court of the state of Georgia, and this thing has gone way too far. We got Brian Steele. He's the appellant in the state of Georgia, the appellee. We got all these attorneys that are involved in this. Y'all see y'all friend right there. Y'all see your girl. Y'all love seeing her name and talking about her, so she's here. That's right, one Ashley Merchant. She's there as well. And these are all the attorneys that are involved in supporting Brian Steele's contempt charge. Again, can't Judge Glanville just say, my bad, I was a little bit hot-headed and pay a fine. I was hot-headed. I shouldn't have done that. Oh my gosh. This just seems like such a waste of legal firepower, legal ability for 5 attorneys plus Brian Steele to be embroiled in this to some degree, shape, or form. It just seems like, well, why? Why? Just apologize and keep it moving. Write a letter, write a report, Judge Glenville. Apologize, write a report, and keep it moving. But no, they're still dealing with this. And Glenville is in the rearview mirror. He's off the Young Thug case. The whole thing was really proven to be wrong on so many other levels. To me, I'm like, it would almost behoove Glenville to be like, yeah, let me go ahead and get this cleaned up. Out of the news, out of the zeitgeist, off of Dear Woke Christian. Let me try to get this cleaned up. Let me get hey, we got a spill on aisle 4. Let me get this cleaned up real quick. Tighten this up real quick. Nobody's going to know. But no, we got this. Part 1. So I'm going to blaze through some of them because a lot of them, again, they give a whole breakdown of everything that happened. And maybe some people have just jumped in, so we will kind of go through that. Then we're going to go through who has jurisdiction, what is the case, and what are the facts. It's pretty simple, but then it gets into the enumeration of errors, argument, and citation of authority, and then lastly, the conclusion. This thing is, again, I'm just like, man, these attorneys, and again, I'm just a pre-K law student. I don't know anything. It just seems to me that these lawyers could be using their skills, their abilities for better purposes, if you will. So let's get down to it. But have no fear. We're not going to read off 46 pages because we know at the end there's the certificate of service. So that's just saying who got served with the document. So it's really only 46. Only 43. Go figure. Let us go. Let us go. All right. Brief of appellant, part 1. Part 1. Statement of jurisdiction. The Supreme Court of Georgia, rather than the Court of Appeals of Georgia, has jurisdiction of this appeal in that the court granted a writ of certiorari on the appeal of this contempt order pursuant to Georgia Constitution of 1983, and I have no idea how to read all that. But let us continue. Basically, long story short, we don't need to go to the appeals. We're going straight to the Supreme Court because the Supreme Court is the one that quashed me having to go to jail in the first place. All right, let's keep going. So there actually wasn't found. Nothing has actually been found. That's a part that is like, dude, just apologize. Dude, get this cleaned up, Glenville. Because it doesn't make him look good. And sad to say, I'm sure he's probably been a good judge. And everything I've heard about him is that he is a good judge. So if that be the case, for whatever reason, Glenville is sacrificing his good career, sacrificing his good reputation on the altar of his pride and ego. Boy, you better get that crow. You better get you some Heinz 57 and eat that crow and be quiet. You can do it with chopsticks. You can do it with a fork and knife. You can do it with your hands. Eat that crow and be quiet. But now we're still here. Statement of the case. And I'm going to kind of blaze through this because it's a lot. It's Brian Steele-esque, right? So he's going through, or the writing is going through, telling the story of the infamous ex parte meeting. And I think it's great. We just have read it already. We know this already, a lot of us. On June 10th, 2024, Brian Steele was held in contempt of the court and sentenced to serve 20 days in custody over the course of 10 weekends based on an incident that occurred during the middle of the trial. The trial court orally denied Steele's request for supersedence bond. Steele filed a notice of appeal and then filed an emergency request for a supersedence bond in the Court of Appeals, And this court then granted the motion for supersedis bond and issued a writ of certiorari so that it could consider the merits of the appeal. All right. We all know that. Again, Glenville, if you're watching, G-Dog, big hurt. Apologize and get done with this. This should not go this far because it's just going to be a blight. Because now all we know of Glenville, if you do a search for Glenville, all you know is this contempt case. Not really anything that happened before. If you just do a search, a Google search, a lot of it comes up around this particular part of the trial. There are other things that come up as well, but a lot of them, sad to say, are not really favorable. If he was a good judge, this is definitely sullying his reputation. This case was docketed by the court on July 3rd, 2024, and on July 11th, 2024, an extension of time in which to file an initial brief was granted. Thus, this brief is timely filed. So they have a certain amount of time that they have to file a brief based upon what it is. And so they always have to extenuate and fill out that, hey, we did file this in a timely manner. I had to file it in 10 days. I filed it in 7. Here's the proof, here's the evidence, here's the receipts. They always do that. Statement of the facts. Steele is lead counsel of record for Jeffrey Williams, State of Georgia versus Jeffrey Williams, Fulton County, indictment number, a 65-count indictment charging 28 individuals with violation of Georgia's, I'm going to call it the right name, Georgia's Racketeering, Influence, and Corrupt Organizations Act and other crimes. Voir dire commenced on January 2023. So we are going into the second year. We're completing the second year, yes. And opening statements began on November 2023 before Fulton County Superior Court Judge Ural Glenville. All right, we all know that. To me, this is yet another reason why I'm pretty sure, just to put a little caveat right here, I'm pretty sure Judge Whitaker is trying to bring this to the finish line, because the selecting of the jury started in January. They didn't start the trial until basically 10 months later, almost a year. Ain't nobody got time for that. Nobody's going to sit there and want to do that again. That's why I really believe if she has to push, pull, drag, tow, whatever term you need, she's going to try to get this across the finish line. That's why I think she's doing this so hard. Here it comes. Friday, June 7th, 2024. In a world. On Friday, June 7th, 2024, prosecutors sought and obtained a use immunity order pursuant for Kenneth Copeland, a witness at trial. After Copeland took the stand and was sworn, he exercised his Fifth Amendment privilege against self-incrimination. Copeland was held in willful contempt and summarily incarcerated over the weekend. The judge announced that when court resumed on the following Monday, Copeland would be brought to court, and outside the presence of the jury will ask him whether or not he wishes to continue to testify. The court adjourned proceedings for the week. Copeland remained under oath as a sworn witness, with both the prosecutors and the court contemplating a contempt sanction that would induce him to purge himself and agree to testify. Trial court saying immediately after holding Copeland contempt, we'll see if we can get some more testimony at that point. I think it's interesting. He keeps quoting what he's saying, we and we'll, because he's making a case. I know where he's going with this. But Monday, June 10th, at 9 a.m. on Monday, June 10th, the court commenced an ex parte meeting in its chamber with one of the two lead prosecutors, two Fulton County District Attorney investigators, and counsel for Copeland in the presence of a court reporter. No defense attorneys attended or were informed of this meeting was taking place. The court did not place the hearing under seal, enter a protective order, or direct participants to keep the meeting in confidence, which I think is super problematic given the fact of all the things that Glenville has said since then. They weren't they wasn't under seal, they weren't under protective order, and they weren't required to remain quiet. That's a problem, Glenville. But let us continue. Copeland was then brought into the meeting along with another lead prosecutor, 2 investigators, 2 deputies, and 2 sergeants with the Fulton County Sheriff's Department. Defense counsel received no notice that the meeting about Copeland's testimony occurred. During the ex parte meeting, Copeland repeatedly made statements that he had lied to law enforcement officers, including that I have never been truthful a day in my life. The court and the prosecutors incorrectly informed Copeland that he could be held in custody until every single co-defendant's case was resolved, not just the trial that was ongoing. The prosecutors repeatedly told Copeland that he could be released from custody to go home if he just testified. Copeland ultimately relented and agreed to testify. Almost an hour and a half after the ex parte meeting began. Contempt hearing. Although defense counsel were ordered to be present at 8:30 a.m. on Monday, June 10th, for trial to reconvene, the court did not convene until 11:52. That was so wild. I remember that because it was almost lunchtime, right? Copeland testified, and then lunch recess was taken. All right. I wish he had said what time, how long Copeland had been on the stand. And I kind of wish he had said what time, but I know there's notes and all that kind of good jazz, but I just wish he had. Over this lunch recess, Steele and other defense counsel learned that the court conducted an ex parte conference with prosecutors and the sworn witness, an unexpected development that greatly concerned Steele, who believed it constituted a significant violation of his client's statutory and constitutional rights. I think he's on the money. I think he's pretty good there. As soon as the court reconvened after lunch, Steele attempted to convey his concern about the impropriety of the ex parte meeting, make a record of the events make a record of the events to preserve the issue for appeal and demand Brady material from the ex parte meeting. The court repeatedly cut Steele off and would not allow him to any meaningful opportunity to make his record. That is really, really problematic, because if you go back and watch, Judge Glenville just kept stopping Steele, over talking him, loudly stopping him, and so forth, because he is almost as if your brother broke your mom's vase, and you're like, Mom, I know who broke his vase. And your brother's like, oh, whoa. Hey, little Johnny don't know what they're talking about. Little Sally don't know what you're talking about. And just kind of put his hands over his mouth like, hey, Mom. Look, no, he doesn't. He's crazy. No, he doesn't. That's what it was like. And now you know kind of why. Because Brian Steele was saying this out loud verbally in court so that the court reporter would have to report it, because that information is supposed to be the record of what happens in court. The court was kind of disturbed because that meeting is ex parte. All that was an ex parte conversation. How did you find out about any of that? Steele responded by citing authority from the court forbidding trial courts from meeting ex parte with sworn witnesses. The court was singularly focused on discovering how Steele learned about the secret conference and continually interrupted Steele, thereby denying him any meaningful opportunity to make his record. The court then threatened, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. The court characterized the meeting and information as proprietary. But when Steele pressed to understand what was proprietary about it, the court could not offer a valid explanation. The court later referred to a violation of sanctimoniousness of the court's chamber as justification for its inquisition. Amazing. Sanctimonious. This is so wild. Ultimately, the court threatened to hold Brian Steele in contempt if he did not reveal how he learned about the ex parte meeting. Steele responded that he was not going to answer that question because he was protected by the attorney-client and attorney work product privileges. The court dismissed that response, claiming that it was not attorney-client privilege without giving Steele any opportunity to explain his basis. The court then took a recess, giving Steele 5 minutes to reveal his source. After a brief recess, the court directed Steele to the podium and told him that there is only one way you could have gotten this information about the ex parte meeting, so I'm going to ask you again. Steele began to cite Georgia Rule of Professional Conduct 1.6, specifically comment 5 about the court prevented. Again, that was very interesting that the court prevented him from being able to speak, and not only speak, but to put that on the record. And by the way, I know I'm kind of reading through it fast. If you are interested in it, down in the description of this video, this document is there. So you can follow along, you can read it yourself, you can read it in funny voices or whatever. Steele, from speaking, and again threatened him with contempt. The court pressed more, and Steele tried to explain his reading of the ethics rule, saying, if you look at comment 5, this is how I understand the law. But the court again cut him off. Steele implored the court, just listen to what I'm trying to tell you. You're saying, but again, was shot down. When Steele was finally allowed to complete his sentence, Steele stated that the principles of privilege and confidentiality prevent him from revealing information gained during a client representation, whatever its source. But I'm telling you, I can't do that under the bar rules. I think he's fine with that. I think he's right. The court offered its hunch about how Steele received information, accusing Steele of eavesdropping. You cannot eavesdrop and get that information. That was not meant for you to hear at that particular point in time. Steele moved for a mistrial and asked for a substantive hearing on the ex parte issue, but the court issued immediately told Steele that he would be held in contempt and taken into custody. The court then offered an alternative to his eavesdropping theory, suggesting that Copeland's attorney, Caleb Bumpus, told Steele about the meeting. After the court found Steele in contempt, his co-counsel, Keith Adams, rose and informed the court that he, too, learned of the ex parte meeting and that he repeated Steele's request for a full transcript of that meeting. The court did not make any inquiries of Adams or demand that he reveal the source of his information. I thought that was interesting. I do remember that. Steele was placed in custody, but later permitted to return to the courtroom to represent his client, although the court maintained he was still in contempt. The court stated that Steele could purge that contempt by just telling me who it was that told you this information. So if you are willing to tell me, it's fine. Then, that will purge your contempt, because the names must be named. Wow. Okay, let's keep this going. Trial proceedings continued for the day, during which Steele's counsel filed a motion to set aside the contempt. And see, this is where I don't understand. Why can't the judge just say, yeah, I messed that up. I did that wrong. Rather than it needing to go to this level of needing to file and such like that. I would like to know a little bit more about why they can't just clear this up without having to, go on your record, go a permanent record, so on and so forth. Can he just say, and if, again, assuming we had a judge that was being honest, assuming we had a judge that was being fair, could the judge just say, you know what? Yeah, I really messed that up. My bad. I was wrong. I apologize. I'm going to buy everybody lunch tomorrow. Everybody can come in at 12. You can wear jeans. I don't know, but Can the judge just say, rather than it needing to go to the level, because in a moment it's about to really hit the fan. He already stepped in his big pile. Now he's about to throw it at the fan. So let's go and let's finish up. After the jury was released, the trial court revisited the contempt issue and pursued its demand that Steele disclose how he learned about the ex parte meeting. Steele alerted the trial court that counsel from Georgia Association of Criminal Defense Lawyers, GATCL, were present and trying to gain access to the courtroom to represent Steele. And I have to tell you, where that courtroom is located, that must have been a sight to be seen, because the hallway is not that big. And so if you add, 10, 15, 20 adults in that hallway jammed in there, right there outside in the little foyer of the courtroom, yes, it was probably packed. It probably was looking pretty wild out there. That would have been something I would like to have seen for sure. Although the court initially stated that there was no space to accommodate Steele's counsel, 2 lawyers were later permitted to enter the courtroom to represent Steele. The court informed Steele's counsel that I've held him in contempt earlier from today's proceedings by him not telling me who it was he got this information from. The court clarified that it was criminal contempt and that Steele could purge himself by revealing the source. Thereafter, Steele's counsel explained that although the court held Steele in criminal contempt, it had imposed a sentence of indefinite detention with the ability to purge, which is a civil contempt penalty. The court reconsidered its position and sentenced Steele to incarceration at the Fulton County Jail for 20 days, consisting of every weekend for the next 10 weeks. The court then entered a written contempt order. Can't they just apologize? I don't expect him to, but can they just do that? Enumeration of errors. Okay, so this is the conclusion. This is the end of season 1. Now they're going into season 2, part 2. Enumeration of errors. There was insufficient evidence to support Steele's contempt conviction beyond a reasonable doubt. The trial court's directive that Steele disclose privileged information was unlawful and created a conflict of interest between his client's interests and his own. And the trial court erred in failing to afford Steele the due process to which he was entitled. That's what I'm saying. Like, dude, you done really messed this up. You flinging big, huge shovels full. Part 3, argument and citation of authority. There was insufficient evidence to support. So in part 2, they just kind of give you what are the things that they're going to argue. So these are the problems. And then we're going to jump into part 3 where they actually argue out those things. There was insufficient evidence to support Steele's contempt conviction beyond a reasonable doubt. Let's go ahead and look at this. Standard of review. On appeal of a criminal contempt conviction, the appropriate standard of appellant review is whether, after viewing the evidence in light of most favorable to the prosecution, any rational tier of fact could have found the essential elements of this crime beyond a reasonable doubt. And there's a code right there. The enumeration of error is always preserved for the appellant review. The use of contempt powers is only appropriate when the conduct in question threatens the administration of justice. Generally, contempt of court refers to individuals' disregard for or disobedience of the order and command of the court, which includes the interruption of the court proceedings. We got that code right there. Georgia law grants state judges broad authority to preserve order in their courtrooms, and the contempt power exists so judges may execute and enforce that public duty, although that power is limited by both the state constitution and the legislation passed by the General Assembly. And we see that code right there. Contempts, the power of the courts to punish for contempt shall be limited by the legislative acts. And we see those codes right there. While the power of courts to punish misconduct and ensure compliance with its orders and directives is broad, it is not absolute. And I think that is something we all saw with Judge Glanville. He was giving absolute authority. I have absolute authority here, and you are absolutely responsible to do whatever I tell you to do. Contempt is a drastic remedy, which ought not to deprive one of his liberty unless it rests upon a firm and proper basis. And we have that code right there, case law right there. When addressing contempt matters, any doubts must be resolved in favor of vigorous advocacy. Courts must be judicious in their approach to adjudicating contempt, precisely because vigorous advocacy is essential not only to the preservation of individual rights, but also to the integrity of the judicial system, whose truth-seeking process is sought to be protected through the exercise of contempt power. Therefore, trial judges must be on guard against confusing offenses to their sensibilities with obstruction to the administration of justice. That is a very, very solid point right there. Therefore, trial judges, Judge Glanville, must be on guard against confusing offenses to his sensibility, his star chamber, his sanctimonious back office with obstruction to the administration of justice. Nothing that Brian Steele did obstructed justice. He's actually seeking more clear justice. It is very clear, I feel, that the ex parte meeting obstructed justice. But I digress. Because again, I think Judge Glanville should have taken the lower road, should have said, yeah, I was wrong, my bad. And clarified it, tried to make it right, get the transcripts and keep it moving. They should not still have to be fighting this. But I digress. To that end, the court must not violate the constitutional or statutory rights of the alleged contemptor, nor may it conduct the contempt proceedings in a way that violates fundamental notions of fairness and due process. I think we all saw that. Because criminal contempt is a crime in the ordinary sense, criminal penalties may not be imposed on someone who has not been afforded the protections that the Constitution requires of such criminal proceedings. And I believe that's what we heard from Ashley Merchant when she came in and argued that, hey, you know what? If you're saying it's criminal, then you have to deal with it this way. If you're saying it's civil, you have to deal with it another way. You can't commingle and take a little bit from here and a little bit from there and make your own contempt charge. Georgia courts recognize two types of contempt, civil and criminal, and we know that already. The distinction between criminal and civil contempt is that criminal contempt imposes unconditional punishment for prior acts of contumacy, that's messed up, Jason. Whereas civil contempt imposes conditional punishments as a means of coercing future compliance with the prior court order. So we see that, as he said, Brian Steele would not be held in contempt if he told if he named names. So it seems like he's mixing criminal and civil and kind of making his own hybrid, is what I'm understanding. While the sanctions imposed for a civil contempt violation may be ongoing without definite end in order to gain compliance with the court's directive, by contrast, criminal contempt is a violation of the law, a public wrong, which is punishable by a fine or imprisonment or both. All right, we have that code right there. The ability to impose sanctions for criminal contempt empowers the court to punish disruptive conduct, which has occurred in the past, when the conduct in question constitutes an imminent, not merely a likely threat to the administration of justice. All right, let's keep this going. To that end, the danger to the administration of justice must not be remote or even probable. It must immediately imperil. Seems like it should be like a helping verb, but it must be. Seems like it should be right there. The standard of proof for civil contempt is preponderance of evidence, and we got that right there. While the evidentiary standard of criminal contempt case is proof beyond a reasonable doubt, the same as in any criminal proceedings, and we got that. Then Steele's conduct did not interfere or threaten to interfere with the administration of justice. And I think we can all see that where they're going right here. They're saying, hey, this is the standard, civil or criminal. You can't have both. You can't have them both. You got to have one or the other. You can't take parts of one and parts of the other, kind of mix them together. But then also they're saying right here, one of the main things is that Brian's, and then this will be part B, Brian Steele does not interfere with justice. So let's keep going. Like all crimes, contempt has an act requirement, actus reus, and a mental component, mentis rea. And we got that right there. To satisfy the actus reus, there must be sufficient proof that the act in question constituted an imminent threat to the administration of justice. The arguments of the lawyer in presenting his client's case strenuously and persistently cannot amount to contempt of court so long as the lawyer does not in some way create an obstruction which blocks the judge in the performance of his judicial duty. I like that. Let's keep going. Courts have found that an attorney interfered or threatened to interfere with the ability to administer justice when, for example, the attorney acts prevent the hearing of a trial or trial from going forward. We got that right there, sorry. Affirming summarily disposition where trial counsel refuses to participate in the motion's hearing. Okay, that will be contempt. I got you. Affirming contempt order where the lawyer, or rather the attorney, refuses to proceed to trial. Importantly, even where a contempt finding is proper, the contempt power of the judges should be limited to the exercise of the least possible power adequate to achieve the end proposed. So you can't just, again, can't use a nuclear bomb to swat a mosquito. Here, Steele merely attempted to make a record of proceedings that he believed violated his client's rights, but did nothing to interfere with the administration of justice. Nothing about Steele's behavior prevented the trial from proceeding or otherwise interfered in the administration of justice. In fact, the court explicitly acknowledged that the exchange with Steele would have no impact on the trial schedule, stating that it was going to move forward with the trial with Steele's co-counsel, Keith Adams, representing Williams while Steele was in custody. That the court intended to seamlessly continue and did continue with the trial approximately 45 minutes after initially taking Steele into custody supports this conclusion. Ultimately, Steele was released from custody and allowed to resume his representation of Williams, and trial proceeded as scheduled. Accordingly, this conviction for criminal contempt cannot stand, even if the trial court's concern regarding the source of Steele's information about the ex parte meeting was legitimate. The court had less problematic alternatives available to it instead of directing Steele to reveal privileged information, finding Steele in contempt, and issuing the maximum authorized sentence. The court should always assess whether there are other correctives sufficient to address the problematic conduct in question. For example, the court could have questioned any of the attendees of the ex parte meeting to determine who leaked the information, or it could have referred to the matter to the law enforcement for an investigation if it believed something illegal had occurred. In fact, the next day, the court entered an order to show cause against Caleb Bumpus, Part C. Steele's conduct did not exceed the boundaries of permissible advocacy. To sustain the contempt conviction, the court must also find that the evidence established beyond a reasonable doubt that Steele knew or should have known that his conduct was outside the bounds of permissible advocacy. As noted above, this element is the mens rea for criminal contempt. As an attorney can only be found guilty if he knows or reasonably should be aware, in view of all of the all the circumstances, especially in the heat of controversy, that he is exceeding the uttermost limits of his proper role as hindering rather than facilitating the search for truth. And we know that right there. Quotation marks and the such were omitted. The court has identified a non-exhaustive list of factors that are probative of whether the attorney knew or should have known that his conduct exceeds the boundaries of acceptable advocacy. Okay, so I think we all can hear, and it seems pretty clear here, that what they're saying is that Brian Steele wasn't going above and beyond. He wasn't doing the most. He wasn't going too far, but rather he was doing exactly what he should have done, and he didn't cross over any guardrails or anything like that because he was doing the right thing. Okay, let me just breeze through some of these real quick. The extent in which the attorney was put on notice prior to the contempt citation that the continuation of the offering statements would constitute contempt. The likely impact of the offending statements on the deliberations of the fact finder, which callous incorporates both the nature and timing of the offending conduct, and whether the fact finder is a judge or jury, whether the offending statements occurred in an isolated incident or constitute a pattern of behavior, the significance of the particular issue in question to the case as the whole and relative gravity of the case, and lastly, the extent, if any, to which the trial court provoked the offending statements with its own improper statements. Goaded. That would be goaded, I think. Not like they used it, but that'd probably be wow. That would be somewhere I think you could say that something was goaded. But let us continue. The record here demonstrates that Steele's refusal to reveal his source was not born out of an obstinance or disobedience, but rather a zealous advocacy on the behalf of his client, who had been deprived of his right to be present during all critical stages of the trial, as well as a good faith belief that Steele had a professional obligation under Georgia rules of professional responsibility and statutory law to maintain that information in confidence. It is a fundamental right and a foundational aspect of the due process of the law that criminal defendants have the right to be present to hear all critical parts of their trials, which include when the judge and prosecutor speak with a witness. And that's something I think is really being lost. And I think I disagree with some other judges. They clearly should have stopped this thing because there was a witness in the building. A witness in the room. But this court need not resolve whether Steele's client was actually entitled to be present for the ex parte hearing, only whether Steele was acting in good faith in following the law as he understood it, which I think is fine. They're standing on the idea that, hey, this is what the law says, and this is why he behaved in that manner. Was he doing the right thing based upon the law, not based upon your sensibilities? Whether the appellant's position on that point of law was correct is irrelevant to the contempt conviction. And this court must resolve any doubts regarding Steele's conduct in favor of vigorous advocacy. Further, an attorney may not be held in contempt of court merely for representing a good faith motion, which he has the right to make. Nor may an attorney be held in contempt merely because, having filed such a motion, he fails to prevail on it. Okay, got you. The Jefferson factors strongly weigh in favor of concluding that Steele was acting in good faith and did not know or believe that his conduct was outside of the bounds of advocacy, although Steele was informed that if he did not provide the requested information, he would be held in contempt. All of the remaining factors weigh in favor of overturning Steele's contempt conviction. There was no impact on the trial, which continued despite Steele's refusal to provide the requested information. Moreover, the exchange of the court occurred outside of the presence of the jury and thus did not impede the jury's fact-finding role. There is no evidence that this was anything other than an isolated incident. Great call. Even the court did not suggest that it was part of a pattern of behavior. Significantly, the two remaining factors weigh heavily on Steele's favor, as he was responding to the court's improper ex parte meeting and trying to make a record of a matter he genuinely believed was of extreme importance to his client's case. Comparatively, the source of information had nothing to do with the underlying case or the issue that Steele was trying to litigate. Taken in totality, the Jefferson factors strongly support a conclusion that Steele did not know that his actions exceeded the bounds of advocacy. His conviction cannot stand. Part D. Steele's alleged contempt was not willful. Finally, I like how they're doing this. I like this. Finally, Steele's conviction cannot stand without evidence that he acted willfully. Here, the record fails to establish willfulness and is in fact replete with support to the contrary. You'll get some cases right there. No person can be convicted of criminal contempt for violating a court order unless they are acting willfully. To prove willfulness, there must be proof beyond reasonable doubt that the alleged contemnor had the power and the ability to comply with the court's order and chose not to. All right. So what he's saying here is that he was compelled by the law and by the rules of professional standards to basically not respond to what Judge Glenville was asking him to do. So it wasn't that he was just being obstinate, just being a stick in the mud, but rather he couldn't because of the Georgia Code of Ethics. Georgia Rule of Professional Responsibility requires an attorney to maintain in confidence any information that the attorney learns through his professional relationship with his client, whatever the source. And they put that in triple black. They are not playing. They put that in triple black. And that's the point. Whoever gave him the information is really a non-issue. It's the fact that he knew about the information. And now it is attorney-client privilege. Comment 5, Rule 1.6 describes how the principle of confidentiality is given effect in two related bodies of law: the attorney-client privilege, which is included in the work product doctrine, and the law of evidence and the rule of confidentiality established in professional ethics. As discussed in mere detail below, Steele could not comply with the court's order without violating his constitutional and statutory duties to his client and his professional obligations under ethical rules. Therefore, his refusal to answer could not be willful. There we go. And so he couldn't. Attorney had both the right and the duty to make arguments to the court. See United States versus Allman. An asserted privilege defeats any willful contempt, and thus there can be no bad faith or willful contempt if the person identified a privilege. While Steele repeatedly tried to make it clear to the trial court, it never seriously considered Steele's assertion that material was privilege. There is no basis for finding Steele in contempt on this record, given the difficult position in which the appellant found himself during the course of this. So again, he was backed up against the wall because he had to do what's right by the code of ethics of attorneys, not just what Judge Glenville wanted him to do. So if you go back to the beginning, this is giving, as the kids like to say, giving that Judge Glenville really lost focus on what is his duty, what is his responsibility, and it's kind of coming out in this. Given the difficult position in which the appellant found himself during the course of this trial, and given the extreme importance of the showing which he is attempting to make on his client's behalf, Part E, the trial court did not make the requisite findings to hold Steele in contempt. Critically, the contempt order here is wholly deficient in that it fails to set forth with specificity, please forgive me, several things, including an explanation of the derelict impact of the court's operations or its integrity of the conduct in question, and the basis for finding that there was no justification for an attorney's behavior. The court's final order contains none of the requisite findings, as it only recites Steele's repeatedly refusing to follow the court's order. And I'm wondering, as I said before, can't they quash this just like they did with the show cause? It seems like they should, or definitely should want to, do away with this quietly, like get rid of it quietly. But I digress. To tell the court how he came into this information about the ex parte conference. While the court's findings focus solely on the fact that Steele did not provide the information demanded by the court, the order does not address in any way how Steele's refusal interfered with the court's ability to proceed with trial or otherwise administer justice, which again, the only reason y'all stopped is because Glenville was in his feelings. It had nothing to do with what Brian did. Commentary on the court that it had, commentary by the court that it had serious concerns about how the information was disclosed and found troubling some of Steele's claims, does not explain or describe how the court this conduct hindered the administration of justice or had any derelict impact on the court's operation or its integrity as required by Schaefer. Clearly, there is no evidence in this record to conclude that Steele's advocacy on behalf of Williams or his refusal to identify the source of his information interfere with the court's ability to administer justice and preside over the trial. Because the court did not make the requisite findings of requisite findings of fact detailing how disruptive conduct interfere with or pose a threat to the administration of justice, and whether the attorney was on notice that his acts exceeded the uttermost bounds of permissible advocacy, the court must reverse Steele's criminal contempt conviction. So this is my question. Could Glenville have said, as I said before, you know what, I messed up, my bad. Now, I don't think he will, and I think we all can kind of see that. But it just seemed like, man, if he just said, I apologize, my bad, I had that wrong. I was power tripping. I was tripping. I just wonder if we would be here, but I'm gonna stop wondering that. Let's go. The trial court's directive that Steele disclose privileged information was unlawful and created a conflict of interest between his client's interests and his own, which is very true. Do I want to go to jail or do I want to give up my client's information? I don't want to give up my client's information. I'm going to end up going to jail. Standard review. The trial court's ultimate rulings regarding privilege are reviewed for an abuse of discretion, while review of any factual determinations underlying those rulings is for clear error. And we got that right there. Oh, thank you so much for the super chat. Thank you, friend. This enumeration of errors is preserved for appellate review as the privilege claims were properly asserted and overruled. Let us go. The trial court could not validly order Steele to violate attorney-client privilege. I think we kind of understood that. And I'm going to kind of scan over these. So now they're explaining where the power and where were the errors. So the trial court could not validly order Brian Steele to violate attorney-client privilege. We understood that because we just read that a moment ago. And definitely read these little small footnotes afterwards. I want to get to there was definitely a really good one here that I want to look at. Okay. By ordering Steele to reveal confidential information, the trial court, improperly created a conflict between Steele's interests and those of his client. And we kind of talked about this as well, that young thug Jeffrey Williams has an interest in this court. Brian Steele has an interest in this court. But because of what Glenville did, Brian Steele had to weigh, going home for Father's Day weekend or going to jail. Telling what he learned about this ex parte meeting, which could impact my client, or go to jail. I mean, like, he created that problem. And I'm going to kind of skip over some of these because I feel like we've already kind of explained them out. Jump down here to the bottom. Part 3. The trial court erred in failing to afford Steele the due process to which he was entitled. And again, and I think it's because Glenville was making this like a hybrid contempt. It was a civil criminal contempt. It was really weird. He was taking a little bit from both. And because of that, you still got to give due process. There wasn't due process. And that's what Ashley Merchant, when she came in to Glenville's court, what she argued is that you can't say it's civil, but treat it like a criminal. You can't say it's criminal, but give civil. You can't do that. It's got to be one or the other. And I'm going to, and if you want, again, I know I'm kind of scanning over some of these, and the whole link to this is down in the description. The trial court erred by failing to recuse itself and refer the matter to a different judge. And I think this is where the rubber meets the road, where the real issue is. As described above, strict due process requirements apply before a court can hold someone in contempt because of heightened potential for abuse posed by the contempt powers. Any trial court considering criminal contempt sanctions against an individual must act dispassionately without a personal reactions or injecting the court into the case. Moreover, where a judge becomes personally embroiled in the controversy that is the subject of the contempt, or where the announcement of punishment is delayed, the judge must immediately recuse from the matter and refer the contempt proceedings to be heard to a different judge. And I think that's where the problem is. And that's actually why, I think there's more reasons why, forgive me, but I think that's really part of the parcel why Judge Glenville's not here anymore, is because he should have recused himself because he was embroiled in this. It was something that he had done. Where the judge reacted to the supposed contemptuous conduct in which a matter to become involved in the controversy, that judge may give the attorney notice of a specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted in front of an unbiased, impartial judge. This court has consistently explained that recusal in the contempt proceedings is mandatory, where, as here, the announcement of punishment is delayed, The contemptuous conduct was directed toward the judge, or the judge reacted to the contemptuous conduct in such a manner as to become involved in the controversy. And we definitely agree to that, where the trial judge does not act the instant the contempt is conducted, but waits until the end of trial to, on balance, it is generally wise where the marks of the unseemly conduct have left personal stings to ask a fellow judge to take his place. I got you there. Revising due to the failure to recuse, and we see this right, remaining for the proceedings in front of a different judge required because there was such a mounting display of an unfavorable personal attitude toward petitioner, his ability, and his motives. Again, you was wilding out, Glenville. You was doing the most, and because you're doing the most, you should have tapped out. But let's continue. Almost finished. Here there is a clear delay in alleged contemptuous behavior. Let me get you contemptuous conduct, and the ultimate imposition of sentence, which is evidence that the trial court should have recused itself. Further compounding the problem, the trial court itself was at the heart of the contempt issue, as evidenced by the trial court having conducted the ex parte meeting, the impropriety and legality of which was the basis of Steele's oral motion, failing to order to disclose the disclosure of obvious impeachment and Brady material to the defense, which was one of the legal issues Steele was attempting to argue. At the time, he was interrupted and then taken into custody, and expressing outrage and extreme concern when it learned that Steele had somehow been informed of the secret meeting. The trial court refused to entertain the serious question presented by Steele motion, or even allow him to fully articulate the factual record and legal issues Steele needed to raise to protect his client's rights. Instead, the court attempted to chill Steele's advocacy, challenging the prosecutor and judge's misconduct, and pointed its accusations at Steele to divert attention to an issue unrelated to the trial. Throughout the contempt proceedings, the trial court was solely concerned with investigating the source of Steele's information. And I think that's really the heart of the matter, is that they weren't concerned about anything that was done wrong as it relates to impacting the administration of justice or finding facts, but rather Glenville was just upset. Let's just tell the truth. Yeah, that was just wild. The trial court repeatedly comments about the sacrosanct nature of the chambers demonstrate that the trial court was personally offended by the idea that the ex parte meeting was revealed and was determined to identify the source of the leak, thereby impermissibly inserting itself into the issue. And there you go. I think right there is recusal should have happened right there once you insert yourself into the issue. But let's finish up. Because the trial court was embroiled in the controversy, recusal was required, and the contempt order must be vacated. That's why I think this should have already, I don't understand why it's still going on, because Glenville was recused, and why is this not vacated, is my question. Or can't it be? Further, a recusal is required in contempt cases, like all cases where there is such a likelihood of an appearance of basis that the judge was unable to hold the balance between vindicating the interests of the court and the interests of the accused. All right, we got that right there. Trial judges must disqualify themselves where their impartiality might be reasonably be questioned in contempt proceedings. Recusal is appropriate in the direct contempt proceedings because one cannot be both the prosecutor prosecuting witness and the judge in our judicial system. And we've seen that when we know Brian Steele even said he was going to call Judge Glenville as a witness. In analyzing whether the judge had become so involved in a contempt proceeding so as to require recusal, the Court of Appeals, has commented that it is difficult to maintain the objectivity required of a fair and impartial judge when you, the trial judge, are deciding whether it is your version of events or the defendant's that is correct. In Steele's case is a textbook scenario where the recusal was mandatory for these same reasons. So they're not saying that necessarily that the ex parte was wrong, but that the fact that he didn't tell anybody and he didn't recuse himself are the problems at hand. Okay, I can dig it. I do think it's a little bit more than that, but I can dig it. The record of this case plainly demonstrates why the recusal rule exists, because there were signs of the actual bias. First, the judge baselessly accused Steele of committing a crime of eavesdropping. Second, the judge did not question any of the other attorneys who received the same information Steele received. Third, the judge initially insisted that Steele was not entitled to any consideration of bond, and then similarly denied Steele a supersedes bond once the court was informed that it was written his discretion to grant bond. It was within his discretion. Please forgive me. The appearance of personal rancor is particularly strong in this case, where the appellants are denied bail pending appeal. And we got that right there. Fourth, the judge did not consider any alternative to contempt to determine how the sacrosanctity of its chambers was compromised. The court should always assess whether there are other correctives sufficient to address the problematic conduct in question. Fifth, the judge completely disregarded Steele's repeated statements that he was not willfully contemptuous, but that the law and ethical mandates prevented him from releasing the information. I think that's fair. These factors demonstrate not just potential, but actual bias. Indeed, the trial court was removed and recused from proceeding over the trial mid-case because of the way it responded to Steele's advocacy on behalf of his client. For all of these reasons, the trial court erred by refusing to recuse itself from proceeding over the contempt proceedings. Why are they not thrown out, though? That's what I just don't get. I know I keep asking that, but it just seems pretty straightforward. Just throw them out. Why do y'all have to even write this? Part B, the trial court erred by using the summary contempt procedure when there was no immediate threat to the court's ability to administer justice. And we kind of talked about this. I am going to skip over this because we know Brian Steele asking the question did not impede the court from doing its job or finding facts or administering justice. Part C, the trial court denied Steele his due process rights of notice and an opportunity to be heard and a representation by counsel. And I think that was really, and we are going to kind of jump through this as well, but this is what Brian Steele was talking about when he went and called Gatkel. And then again, we know that Ashley Merchant and another attorney, I can't remember his name, both came in and they gave Glenville the business because what they were doing, what Glenville was doing, was wrong on its face. Whether civil or criminal, the trial court denied Steele the due process to which he was entitled when it initially held him in contempt. And I think that's fair. We saw that Glenville was power tripping, Glenville was doing the most. And I'm going to kind of breeze through these ones because I didn't want to take too long to read through it all. But down in the description, if you would like to, all of this is down there in the description as well. And so that was part 1, and then part 2 right here. Even if the court properly used the summary criminal adjudication procedures, it still deprives Steele of meaningful opportunity to be heard. And long story short, by not allowing Brian Steele to say anything, by not allowing Brian Steele to have any word in edgewise, they actually are violating his rights to be heard if he was doing something criminal. If he wasn't doing something criminal, then if he was doing something civil, then there's another problem too. So it just, again, Glenville really stepped in it. Now, when the trial court imposed that final criminal contempt sentence, it still failed to afford Steele the due process to which he was entitled. And I really feel like this was a restatement of part 2, but we're going to get to this conclusion very quickly. As described above, the trial court abused its contempt power by holding Steele in contempt when Steele was fulfilling his duty to zealously advocate on behalf of his client. And it did so without affording Steele any of the due process protections required by law and without recusing itself as mandated, because there is no basis on which to conclude that Steele was engaged in contemptuous behavior, and the record and contempt order are deficient as revealed, or rather as a reversal of the conviction of the conviction is warranted without remand. Remand is only appropriate in those cases where there was proper record made at the time and the order is inadequate but could be made adequate upon review of existing record. In cases such as this, where no record was properly made below, remand is clearly inappropriate. So holding Brian Steele without bond is inappropriate, is what they're saying. Summary. Remand only required where the record establishes some basis for of a finding of contempt. Remand is not appropriate where evidence is legally insufficient to support the conviction because the state cannot rectify the evidentiary deficiencies on remand. Sorry about that. 1 second. All right. This submission does not exceed the word count limit imposed by Rule 20. Respectfully submitted on the 22nd day of August 2024. And there's all the signatures of all the smart people. There's a quick summary of this. And it was signed by another smart person. And then the order of service. All right. And I apologize about that, but I want to thank y'all so much for that. All right. Wow. Okay. Right here on the spot. Okay. So that was Brian Steele's motion. And I want to thank y'all for hanging out with me. Real quick, Amanda Timpson just texted me. If you're familiar with Amanda Timpson, she just texted me and said, look up my new motion. All right. That was just issued yesterday, or today rather. Oh my gosh. Let me see if I can find it real quick. She asked me to look it up because she says it's something good. All right, let's get this found. Okay. I think this is it. No, that's not it. Sorry. So she just texted me and said, look at my motion. She's Amanda Timpson is the whistleblower that used to work in the Fulton County DA's office and came forward to say how Fonnie Willis was not using funds correctly in her office. Well, she's been in a back and forth battle with one Fonnie Willis, and apparently okay, I see some good comments in there. All right, I'm trying to find this motion that she just told me. She literally just texted me and said, look up the new motion. She didn't give me a page number where to find it. Oh my gosh. Okay, let me. Man, we are live. We're doing this live in real time. Oh my gosh. All right, I don't think I have. I found tons of them, but I don't know if this is. No, this is not the most recent one, clearly. Okay. All right, I might have to do some digging and some searching, some scraping and scraping, scrambling. All right, I don't see it. I got to check real quick because Texan is a great researcher. Okay, I don't see it. Let me. Oh wait, here it is. Okay, let me. All right, let me. Let's see if we can get this right. All right, so she sent me the where to look for it. I think I got it right. I think I did. So what I'm doing is, all right, so where's this motion? Most recent one. Can you sort it by most recent? Yeah. This poor woman been fighting with doggone Fonnie Willis for so long. All right, let me see if I can get. Yeah, this is still dog. I still don't have it. I'm in the right place. I just can't find that motion. Let's see if I can get an advanced search. All right, let's do this. All right. I can only find 2022, not 2024. I'm looking in the right place though. Okay, so real quick, and I apologize. I'm looking for Amanda Timpson. And I don't see her recent motion in her case. All right. She asked me to look at it, but I don't see it. I don't know if it might be user error. I'm going to go with user error because it's probably me. Yeah, I don't see it. I'll find it, but I'm not seeing it now, and I don't know what I'm doing wrong. But I will come back and I will go over that with y'all because I think it's probably going to be really interesting. She told me it's going to be an interesting read, but I don't know how to. Let's do it like this. All right. Oh, mercy. Let's try this. Yeah, I don't see it. I'm just fumbling and bumbling. I don't want to keep doing it. Y'all, thank you so much. And this was like really just a members thank you type of live stream. I wanted to go over what Brian Steele was doing again. I just thought it was very interesting that they're still fighting that contempt charge, even though Glenville is out of the picture. They're still fighting it, which is kind of wild. But I do want to say thank you. I do want to say thank you so much to Mandy. I appreciate the super chat. Appreciate you. Thank you so much. What did she say? She says, love you all. DWC is the GOAT. That GOAT comment yesterday went that thing went nuclear for sure. I'm going to get you. I don't see him. I can't to see Amanda's. I don't see it. I'm looking for it. Republic T, and hopefully I'll find it and we'll do another one. Maybe we'll do it tomorrow or later on tonight. I think the kids are going to the football game and my wife's out of town, so I can go back over that and we can talk about that. That'd be fun. But I do want to say thank you. I did not want it to be all day. Thank you so much, Cammie, for stopping through. I didn't want it to be all day. I just wanted to jump through real quick and say thank you again for your being a member. Thank you so much for supporting the channel and all that you do, from being a part of the best live chat to commenting to membership. All of that, it means a lot. I really do appreciate it. And I just want to do this quick little live stream today to kind of go over what's going on with Brian Steele, give you a little update on that, and again to say thank you. So I really do appreciate y'all. The goal is to, once I find this, we'll do it again. Maybe we'll just do a live stream and just rap with everybody. But the goal is to, this weekend, got a couple of videos I'm going to drop. On Monday, we'll be doing a live stream from here at the house. I'm probably going to go to the courthouse on Tuesday or Wednesday. Depends on what day. I really believe Brian Steele is going to get his hands on Woody, because that's going to be some must-see TV, and I want to be there for that. But besides that, we will be here or at Podium Studios. And everybody, I want to thank you so much for that. And I will see you all very soon. I want to thank you again for all that you do. And until next time, everybody, grace and peace. Take care. Have a great Friday.